matter of West and another, and Stockport and Trust.
I'm sorry we're a bit late, Mr. President.
Apologies should really come from this side of the court in terms of the procedure that was adopted immediately before the appeal in terms of skeletons, and so I certainly accept on behalf of learned friend Mr. Madlew your apology, but I wish to apologise myself for the delay that was caused in the receipt by the court of skeleton arguments. We have made an application in respect of them, which I hope are self-explanatory, but I accept that there should have been, particularly with my Lord Justice Irwin, there should have been greater communication between us to ensure that you're aware of our difficulties in trying to arrange professional commitments to get the skeleton prepared in time, giving the timing of the receipt of the skeleton. So I do apologise for that.
We're hoping we can get through this case in well under 2 days.
Yes.
The skeletons are very full, and the issues are quite narrow.
Yes.
The answer may not be clear in all respects,
Yes.
but I think the issues are clear.
They are, indeed. And I will obviously, as is common, be guided by your Lordship on the areas of which greater emphasis needs to be applied. I should say, if I remember I've done so, that the learned friend Mr. Madlew appears on behalf of the two trusts, and I appear with Mr. Rupert Cohen on behalf of the appellants. As my Lord knows, this is an appeal from His Honour Justice Smith back in March 2017, and it is an important case. All cases here are important, but in the context of the costs world, it is an eagerly weighted authority case, because there are a number of cases, I understand hundreds of cases, certainly on our side from ARIG, I think 60 was referred to by the assessors, that are sitting waiting up and down the country for determinations as to the correct approach to take to the assessment of these premiums. But moreover, the case is, I think, the first opportunity for the Court of Appeal to express a view as to how the proportionality rules are intended to operate in principle across the piece, so to speak, whilst also directing one's attention to the premiums. One can't avoid submissions about, and hopefully rulings about, how it's all supposed to work, because there has been some inconsistencies in approach. The Court of Appeal in McMenemy observed right at the end, I'll come to it later, but at paragraph 79 for your note, this was the last time this issue of the premium, of these premiums, were before this court. Lord Justice Lewison said, "I think that it's unfortunate that the Rule Committee took the view that there was no need for rules or practice directions dealing with the recovery of ATE insurance premiums in clinical negligence cases, and would invite them to reconsider the question. At the moment, however, the pieces of the jigsaw puzzle are manoeuvred. They do not fit properly." So that we are in a world where some guidance is sought to be derived from the case. It's ultimately a matter for your lordships, but we would hope that we can, both of us, assist you in respect of that. As your lordship says, in respect of these two appeals, actually,
Well, I think that's a very important point. At the moment, but I may be wrong about this, reading the skeleton arguments, there doesn't seem to be much common ground about proportionality.
no, quite,
And so just saying you hope that we can do better
yes,
is not actually terribly helpful.
yes,
What we've got to try to find some way where, if we don't accept one particular extreme end or the other extreme end, but there's something in the middle somewhere,
yes,
what it should be. And I think that's what we'll be seeking to do in the course of our exchanges with both of you.
yes. I perfectly understand that and see that, and rather assume that would be the approach the court would wish to take. But as my lord says, actually in terms of the issues in the case, ignore for the moment the wider application of proportionality, the issues are actually quite narrow in the light of the assessor's report particularly, which was a report instigated on application, but ultimately by this court, by Stephen Irwin, who made an order that there should be a fact-finding hearing. And you know what we say about that. We say that a lot of the arguments about the reasonableness of the premiums falls away in the light of what the assessors have said about the premium, such that in West, the issue in that case is an issue simply on what is a reasonable premium on the facts of the case. The premium was reduced by the district judge to £2,500. He did so on the basis of evidence of what he believed to be alternative, cheaper policies. His decision was upheld by His Honour Judge Smith. Those alternative, so-called cheaper policies, as it happens, were in fact not available at all to the claimant in that case. The assessors have so found, and I'll take you to the relevant passages of the report in due course. The remaining question, though, for the purposes of the appeal and for future cases, is what is the appropriate practice? What is the evidential burden on a paying party in seeking to challenge a premium of this kind? And the split between us, Mr. Maliou's case, is that it's all that's necessary is to show that there are some cheaper products available, and that places upon then the claimant to establish why the particular premium claimed is reasonable. We say no. In the context of block-rated premiums in particular, some expert evidence is required, some evidence going to the rating of the premium, the overall approach taken by underwriters is required in order to establish that the premium is unreasonable. And those 2 points are the foundation of grounds 1 and 2, and that's what West is about. So it's about what is the required standard of proof and why, and I'll take you to all of the arguments in support of that. So far as the Demouilpied case is concerned...
Just on that, the concentration you say is on the question of what's reasonable. What about necessity? Where does necessity come into this?
Well, on that particular case, the position is accepted by both of us. Issues of proportionality were not raised in the case on the premium,
Right.
and so
it's necessary and reasonable.
Yes.
And proportional. There are 3 elements.
Well, there are 3 elements. Although, as we will jumping ahead, as we see in the rules, the standard of necessity actually doesn't appear in the rules. There's a reference to it in the proportionality test. The 2 tests are: is it reasonable, and is it proportionate? They're the 2 standards.
Speaking, there wasn't, as I understood it, there wasn't any challenge to necessity.
Correct. And
because you can't litigate like this without the expert support.
that's right. That's correct.
So that's my question, if I can refine it, is does necessity simply go to what it is essential without which you cannot litigate? Is that what it means?
That's what it means. That's what we say it means, and we say so. That's what we say it means. But on just as a matter of procedure and fact, so to speak, in the West case, the only challenge to the premium was that it was unreasonable in amount.
Yes.
And that's the basis upon which His Honour Judge Smith dealt with the appeal, and it's the basis on which we're before your Lordship today. Is the decision of the district judge that it was unreasonable amount correct? So far as the Demoulpied case is concerned, that is a case which does invoke the proportionality test. There's no dispute that it was reasonable in amount. The issue is whether it is disproportionate. And so through both appeals, we get to the point that the court is really examining both limbs of the rules, reasonableness and proportionality.
But in fact, both district judges simply said, well, it looks a bit high to me.
Yes.
I mean, it's now all these arguments, proportionality, reasonableness, whatever. But that effectively, the appeals spring from the same one sentence point.
They do, and the same springboard, as we shall see. I will. It's a little bit painstaking, but it's important for you to understand how we got to where we got to. The NHS has had a policy, pretty much, of approaching these premiums on a case-by-case basis by saying that there's an alternative LAMP policy. It's usually the one that's run out. And it's that, my lord, that triggers the mindset of the master or the cost judge involved that, oh, there's something else that's cheaper, it's excessive, therefore I'm going to reduce it. And as my Lord Justice Coulson observed, both district judges were presented with the same comparable evidence. the judges arrived at reductions, one based on reasonableness and one based on proportionality, but ultimately they were absolutely affected or infected by the deployment of this evidence, which the assessors, after days of evidence and cross-examination, have said actually, there's nothing obviously unreasonable about this premium at all, and certainly no other approach was even put to my witnesses at that during the course of that hearing, as I shall take you to. And B, the policy that's being relied upon up and down the land actually isn't available anyway on the facts of the cases. So that pulls the rug from the starting point, and we look afresh as a consequence at the decisions in the light of the assessor's report.
What is the? We were told there's a two-stage process.
Yes.
Looking at the bill as a whole,
Yes.
and then if it was not disproportionate as a whole,
Yes.
then basically you're not doing very much. But if it's disproportionate as a whole, you then go through the individual items.
Yes.
Does that still apply, that approach, and was it followed here?
Right. So that approach, as one quite properly observes, is an approach that was adopted by the Court of Appeal in Callering and Lowndes, where Lord Wolfe in Lowndes had to come up with a solution to the problem that the rules didn't actually tell anybody how proportionality, which was a principle that existed pre-Jackson, if I can use the word pre-Jackson to identify the period before the 1st of April, proportionality was in the rules, but the rules didn't tell us what it meant. And so in Lowndes, as we shall come to, the Court of Appeal, it became a practice note, said that the way to deal with proportionality is to start by looking at the global figure claimed in the bill of costs. And if it appears to the assessing judge that it's disproportionate by reference to the value and issues in the case, then you apply a test of necessity. You go through the bill and only costs which are effectively necessary will be allowed. And it was a neat solution at the time to the problem. And what subsequently has been divined from the experience of the courts and Lord Justice Jackson's report is that it wasn't a sufficiently rigorous test, such that Lord Justice Jackson recommended that the rules be added to so that there is specific reference to proportionality and what it means. The problem, as we shall see, is that those rules don't really tell us a great deal about how you're supposed to apply the test. But so, in answer to my Lord's question, the Master Lord's question, the Lowndes test was intended, certainly by Sir Rupert Jackson, he says as much, to be jettisoned. I shall come back to that in due course, such that it's replaced with a new approach. But the approach is actually missing, it might be said, from the rules, and that's part of the problem here, as observed by the Court of Appeal in the McMenemy. The courts up and down the land are grappling with how to deal with proportionality. Some judges are now approaching it this way. They go through the bill on an item-by-item basis and decide what is reasonable, ignoring proportionality. And then when they arrive at a figure, they stand back and say, is that figure proportionate? And if it's by reference to the new factors, if it's not, they do different things. Some judges just simply take a straight, I'm going to allow half of it, without much reasoning. And others have been more forensic. His Honour Judge Dyke, for example, in the May case, a case which we'll take you to later, was more forensic. Said, well, I'm still very happy with the fact that these costs here were necessary. I'm not going to disallow those further. For example, the issue fee, that was a fee that had to be incurred, and I'm not going to tinker with that. But I'm going to tinker with the council's fees or the barrister's fees that were incurred. I've allowed reasonable figure, but actually, standing back, looking at proportionality, they should be reduced still further. And that is the approach that has been taken. That's not guided, this two-stage approach, is a different two-stage approach to the Lowndes, it's a new two-stage approach. It's not in the rules, it's not in the practice direction.
Just so I understand this, so basically this is where what the cost judge does, he goes through each item, some they alter because they can't change it, some they say not reasonable. They then get a figure at the end, and they say, well, looking at what's being recovered, is this a proportionate amount?
Yes.
And if they say it's a proportionate amount as a whole, that's the end of it.
Fine.
If they say, well, I still think it's disproportionate, they then go back through each item again? Is that what you're saying?
Well, there were different approaches. So some, and this is what we really need to explore with the lordships about what should be. Maybe the lordships won't want to do that, but there's a pressing need for some guidance here, because some judges will say, I'm not going to just pluck an arbitrary figure from the air and just say £50,000 is a proportionate figure, whatever, because that would be unprincipled. So they actually go back and look at what they've allowed and try and arrive at a principled decision on proportionality. Others, though, have said it's disproportionate.
In relation to each item.
In relation to each item. Or categories of work. Categories of items is probably a more appropriate expression. Others have said, no, it's disproportionate, I'm entitled, the rules don't prevent me from saying, I'm going to just allow 50,000 because I feel that's a right figure.
Yes.
And the problem with that is it looks unprincipled, it suffers from the consequence that it can be criticised as being purely arbitrary, actually, which is not something which the law, I would submit, really should encourage. It's not desirable because it removes predictability from the whole assessment process, which just drives this industry still further into further hearings and challenges and so on, which benefits few.
Does anybody judge the matter not by reference to what's been recovered, but to what, this is particularly in a personal injury case, but to what the claimant might reasonably have thought would be the value of their claim at the beginning, but hasn't actually turned out to be the case? Does anybody do that?
That is possible because the wording of the rule on proportionality is proportionate to the matters in issue. It's not proportionate to what is recovered. And so it's absolutely open to a claimant to say, well, I reasonably believed my claim was worth 200,000. I accept it's been reduced to 50. But at the time, when I was undertaking this work and instructing and so on, I was pursuing a claim which I reasonably believed to be high value. So,
I understand. I might have a slightly more refined question, because do any cost judges actually do that?
I don't think we've got examples of that in the.
Because that could involve quite a lot of work.
Yes.
On hindsight.
Yes. But I mean, it could, and there's a danger of applying hindsight in all of this, which hindsight throughout, certainly so far as cost jurisprudence is concerned, has been a paramount, significant bedrock that when assessing costs, you don't apply hindsight. You don't apply the current lens in looking at what was reasonably undertaken at the time. You have to take account of what was going on at the time in arriving at what is a reasonable cost to incur or expend. And we would say that's absolutely, that should remain, and there's no suggestion that that's changed as a matter of principle. And so, because the problem...
Sorry to break in, but if that's right, if you start with a properly thought through, reasonable anticipation of £250,000 damages, and you end up, for one of the many reasons that might arise, with 50,000, and proportionality is judged in relation to 50,000, not the 250,000, in what way is that proportionate?
Well, look, so
it is an exercise of hindsight.
Right, but we must also remember that the fact that the claim was valued at 250 and settled, or was ultimately awarded at 50, is likely to be reflected first of all in the cost order. So the cost, the judge determining the outcome of the claim is quite entitled to say, I'm going to reduce your recoverable costs because you've exaggerated your claim or you've arrived at a figure, and can make an order that respects that defeat in terms of the 150,000 in the example given. But when it comes to assessing what is the reasonable sum to pay, depending on that order, we would respectfully submit that you still have to look at what was in the minds of the lawyers, because reasonableness is an objective test based upon what was known to the parties at the time they incurred the costs.
Yeah.
And so you are forced to recognise that and to examine what was the position on the ground at the time the costs were incurred. And so what you can't do, we say, is come along with a proportionality sort of trump card and say, well, it's all disproportionate at the end. Of course you can say it was disproportionate when it was incurred, bearing in mind what you knew. Absolutely accept that. But there's a real danger in saying there's a new wind we can apply proportionality at the end and apply hindsight and say, as it turned out, the claim settled for 50,000 or was tried at 50,000, and as a consequence, this was a case that was never going to be worth £200,000. We're going to reduce the cost on proportionality grounds. That would be wrong. If at the time the work was undertaken, it was proportionate to do it, it should be allowed.
Well, this is under the reasonableness head.
Under both. So reasonableness and proportionality has to be judged by reference to the work that's being undertaken at the time it's undertaken.
So you said, sorry, your submission then, if it's proportionate when it was incurred,
Yes.
then it's proportionate and should be recovered.
Yes.
Now, where do cost budgets come into all this?
So
Because they do look at the position as at the time.
They do.
So those are forward-looking, not retrospective.
And it supports my overall approach because obviously cost budgets don't apply to these cases. They weren't budgeted, but the vast majority of cases are now budgeted. And the way the rules work is that you budget at the time that you budget early on in the proceedings. You say to the court, this is what we expect to incur going forward based upon the value of the cases we understand it to be, the steps that are required to be taken to get to the end game of a final conclusion. And the idea is that that figure, once assessed and determined by the budgeting judge, will be the costs that you get at the end of the case. And you take account of proportionality. There's a case called Harrison. It's not in our bundle, actually, and it maybe was something that we could...
Harrison.
A case called Harrison, where this court examined the interplay between proportionality in budgeting and proportionality on assessment.
That sounds quite important.
Yes, and the Court of Appeal held that you take into account proportionality at the budgeting stage and at the end.
As somebody who's done more than my fair share of cost budgeting, I'm bound to say that was always my understanding.
Yes.
That you take into account proportionality and reasonableness, you set the budget, those are then the costs, and then you circumvent many of the arguments that we're going to have in this case.
Correct.
Because you simply have the figures.
That's right.
And I know cost budgeting comes in for a lot of criticism, but my own view is that those criticisms are undeserved.
Yes.
And that cost budgeting does avoid the sorts of debate that arise in this case.
We would agree with that. I mean, it does avoid the sorts of arguments that arise in this case. But in answer to my Lord's question, the issue of proportionality remains an issue to be determined at the end. The court can depart from a budget if there's good reason to do so.
I appreciate that.
And so it will be open to a paying party to have a squabble about whether there's good reason to do so based upon presumably proportionality. I mean, it might say this turned out to be a case worth only 50,000, and the budgeting judge budgeted on the basis it was a £250,000 claim.
All right, so let's see where we are. I'm sorry, we're not really letting you develop your case.
No, I'm perfectly happy to.
And I appreciate
It's
that.
enormously helpful.
But I think we're trying to get to the heart of it as
Yes.
quickly as we can. So, your cases, we obviously haven't yet heard this, but your case is that I think you're saying there is a relationship between reasonableness and proportionality, which we'll have to explore.
Yes.
There's some kind of relationship between them. That proportionality is not something to be judged simply at the end on the amount recovered, but it does take into account, as it were, on a continuum from the time you begin as matters develop.
Yes.
In the case of where cases are cost budgeted, that is inevitably taken into account because you're assessing the budget and what's reasonable looking forward to
Correct.
the early date of the trial.
Yes.
And therefore necessarily that does take into account what the parties expect will happen
Yes.
and should happen, what
Yes.
is going to be reasonable. So there's not a hindsight there, it's actually a foresight. And that it's only where at the end of the day there's a good reason for varying from the budget that, as it were, you'll come in with a new proportionality assessment of the
Yes.
whole thing. But assuming that doesn't happen, then at the end of the day, because you're going to be restricted to what's under you'll recover what's under the budget. There's an inbuilt proportionality which is on a kind of time continuum.
Yes.
Now, not all cases are budgeted.
No.
These were not.
No.
What do you want to say about that?
So, but just before I move from that, so that, and the other thing about budgeting is, as Lord Justice Coulson knows, because he was in a number of the cases, if a party believes that their budget needs to be reviewed because there's been a change in their attitude to the case, because they think they might not any longer be claiming £250,000, then they should revise the budget. There is an obligation to keep budgets under review. And the second point I wanted to make, that we're here concerned in these two cases with ATE premiums. They wouldn't ordinarily be the subject of a budgeting exercise because the rules say additional liabilities are outside of the budgeting regime. Not that that matters for the purposes of the debate we're having at the moment. But I just wanted
didn't
to
know
flag
that. So ATs are outside the budgeting.
Yes, it is. The
Why
form
is that?
says success fees and ATE, insofar as they're ever are not part of the budget.
Is that in the rules?
Yes, it's somewhere in the rules. We can dig that out. It's on the precedent H. I think it actually says this does not include.
Yeah, it's just on precedent.
We agree with that.
It's on the precedent.
So it's on
the form. The stated
it's on
form.
an approved form.
Correct.
Precedent. Was it precedent?
Precedent H.
Oh, was it approved? No, I do know about that.
Precedent H. Yes. So, but coming back to my lord's question, where costs have not been budgeted, then you're left with the prospect of an assessment at the end, where a party is quite entitled to say these costs are unreasonable and disproportionate. But my point is that when determining whether something is either reasonable or disproportionate or proportionate, you do so not with the benefit of hindsight. You do have to respect what was being undertaken at the time, because it's a question of, were these barristers, for example, acting proportionately in drafting the 5-page, whatever it may be. You have to look at what was going on at the time. Now, it's cumbersome, but that's what's been historically the position throughout the course of all of the jurisprudence in the cost assessments from year dot. In the very early days of recoverable costs, legal aid, all cases all approached on the same basis. You look at the work being done at the time. And so there's a real risk with this proportionality test. If you just at the end say, I'm going to allow X, plucking figure in the air, that actually what you're doing is applying a potentially extreme form of hindsight in not respecting the work that was being undertaken at the time and the reasons for it. And there needs to be some caution exercise there, which is why we will say that there does need to be something forensic, not overly forensic, but there does need to be, when you stand back on the if a two-stage test applies, I'll come to that in a moment. It's not in the rules, but if it does apply, then there should be a proper exercise of examining the areas or the items of cost, probably areas, categories, that should be revisited, giving a reason why they should be reduced still further on the grounds of proportionality, rather than just saying a figure of 30,000 is a proportionate figure to pay. It's a very pernicious way of proceeding, and it causes huge uncertainty as to, I mean, one problem with that approach, we'll come to it in more detail, but one problem of just saying a judge is entitled to say at the end, stand back, I've assessed the bill at 99,000, but I consider it to be disproportionate, I allow 30, which is pretty much what's happened in one of these cases, is that you might as well just say to the judge, well, did you think 30 was proportionate at the outset? If so, why go through the assessment of reasonableness in the first place? So that second limb of this so-called this new two-stage test needs to be exercised with some care.
It's unprincipled.
Yes, that's really the point. Now,
this is the first thing I want to ask you. Has anybody actually said, in some sort of authoritative judicial statement, that there's a practice direction that came with allowance, that no longer applies?
So far as cases are concerned, His Honour Judge Dyte in the May case, which I'll take you to, said as much.
Said it didn't apply anymore.
Correct. Yes.
I mean, Sir Rupert indicates that
Sir
in
Rupert
his
indicates
report.
He does very clearly. I mean, his report says it in spades that the idea of this rule change is to jettison Lowndes.
Right. So that test was quite a specific one, which is if the end result's disproportionate, you only allow such which are necessary. So that's a very specific issue. So are you asking us to say at the Court of Appeal level that it is gone? You're asking us to say that officially it's gone.
Well, can I just, in McMenemy, we'll come to it, McMenemy, the issue of Lowndes was referred to, I mean, it has been accepted. I just want to make sure that this court, I think in McMenemy proceeded. McMenemy's behind tab 8, and certainly the submission being made by my learned friend Mr Malley in that case, we appeared against each other, was that Lowndes had been reversed, but it doesn't look as though, I don't believe the Court of Appeal went on to deal with that, because the issue of
You can come back to that.
Yes, I will.
But anyway, your submission would be: are you both in agreement on that point then, that it should be clear that no longer applies?
yes, the two-stage approach advanced by Lowndes of looking at what is globally proportionate, and then going through necessity doesn't apply. That's the purpose of the.
So
But that's not to say what Lowndes did was to say, if something is necessary, and this is where we get into necessity, which is in the middle of the rule, but not actually referred to as a principle of cost in terms of what should be allowed. In Lowndes, the Court of Appeal said if something is necessary, it's presumed and treated as proportionate. End of. And it was a very neat solution. And I still say, and I will be saying today, that where it all depends what you mean by what is necessary, but where something is absolutely critical or necessary in a case, I find it hard to see how that can also be disproportionate. The language.
I think saying something I find it hard to see. What's your submission?
The submission is it's a submission on behalf of the clients, but it's also a strongly held personal view that where you have a cost which is necessary, you had to incur it to bring a claim. By definition, it can't also be disproportionate.
Unless you get to the position where you recognise for this claim to proceed such a cost would be necessary, but it's too big a cost and I should cease to sue.
Cease to sue. In other words, it affects you absolutely. And if it's absolutely.
There will be cases where you say, well, I'm not going to spend £10,000
yes.
on the insurance policy in order to recover £2,200.
If necessity is not equated with proportionality, as you say, then I agree. That will impact on the ability or the enthusiasm of claimants to pursue claims, because the idea is you get back the proportionate necessary cost.
What it recognises is where something would clearly be disproportionate to proceed from the beginning, or at least, and sometimes maybe in the middle.
Yes.
You realise it's not worth spending and risking more money to carry on.
Yes, unless it's recoverable as a necessary cost. It's a bit of a roundabout. We go around in circles, because if you know from the outset, actually, the way that the rules work is that it's an expensive but necessary cost. It's actually proportionate. Then you will recover it, because the rules allow the recovery of proportionate costs. So it does turn on.
That is to say, once it's necessary, it's automatically proportionate. So
So sorry to interrupt, Lord. That's what Lowndes was saying. And I agree that the new rules move away from that.
Yeah.
We say, as you know from Skelly, that we say where something is necessary, it may well be still capable of being allowed, but it might also be reduced, or indeed, it can be reduced or disallowed entirely, even if it's necessary.
So you accept that Lowndes has gone?
I accept that to that extent it's gone, because we say that clearly. We say our case is that under Lowndes you treated necessary costs as proportionate. You don't any longer.
No.
But it doesn't mean that if something is necessary, it's automatically disallowed.
No.
because it all depends on what is necessary. And preparing for the appeal, you go round. I promise you will all go around a little bit in circles on this, because the language used is not perfect. But we say that where an item of costs has proved to be necessary, when you come to your assessment of what is proportionate at the end of the assessment process, you should absolutely have regard to the fact that there were items of costs or categories that were necessary. Some might not have been. You might have been able to get a cheaper barrister. You might not have needed to employ such an expensive solicitor. And where reasonableness is engaged, you can see where that can be reduced more easily than a cost which is a fixed cost, a necessary fixed cost, which, for example, the court fee I gave. We would say that the AT premium here falls into a similar category. There's no other way.
Maybe necessity should be reduced. Sorry, let's start again. You have three different concepts. Now, there may be an overlap we'll have to explore. One is necessity, one is reasonableness, and one is proportionality. They're three different concepts.
Yes, they are.
And you have to allocate to each of them some kind of meaning. They can't mean exactly the same as each other. And maybe what we should be saying, I'm putting this out to you as a suggestion, is that necessity is limited to those things which every litigant, whoever you are, has to be like a court fee. That is necessary.
Yes.
You have to have a court fee, for example. There may be others in the same category. Once you go away from those things which every litigant has to have, whatever they're doing,
Yes.
By virtue of the nature of litigation, you're then into the area of what is reasonable. Now, and one of the things I'm going to ask you about is, at the moment, I'm slightly getting the feeling that you're coalescing the concept of reasonableness and proportionality, but they're not the same thing.
No, I'm not. No.
So it may be reasonable for a litigant to do something,
Yes.
but it may not be proportional.
I agree.
And I'm yet to hear how you're going to articulate the difference in those two concepts.
Yes. But they are different concepts. Because you can have a reasonable item of costs which wasn't actually necessary.
No, I'm talking about
So that-
necessity.
Yeah, no, but that's
I'm dealing with reasonableness and proportionality now.
yes. But a cost can be reasonable but still disproportionate,
Right. Can you give me an example?
and that is because it's. I'm afraid it does involve an exploration of what is necessary, because it informs the debate. If you have an item of cost which is reasonable to incur, in the sense that that this was a perfectly reasonable thing to do to go to the barrister, but it might not have been necessary, there is a margin there for proportionality to come in and say it's reasonable, but it should be reduced because it wasn't necessary to incur it. So that is how we say the proportionality third different concept can play a role. And we'll come to the approach that this court took in Rogers in distinguishing reasonableness from proportionality and necessity, the three different. Because what we say is that actually nothing has changed so far as what Lord Justice Brooke did in a judgment which has stood the test of time. It was a marvellous judgment in which he sought to analyse the very. We'll see it. We'll look at it shortly. In which he sought to analyse the different concepts. They're the same concepts today. We must remember that. It's just that Lord Justice Jackson's amendments have crystallised, to some extent, what is meant by proportionality, which was absent when Lord Justice Brooke opined on the concepts in Rogers. So we'll get to analyse that. I have gone off track, but it's been very helpful to do so, and I'm more than happy to be diverted by any questions, of course, as one would expect in this
back on track, can I
illustrious
disturb
court.
you with one more? One concern about the proportionality test relating to the decision at the time, as opposed to the outcome, might be the amount of preparation and analysis that the cost judge is faced with.
Yes,
I
understood.
want to explore that before
Yes.
I lose focus on. If the question of reasonableness has to be investigated by the costs judge, then that cannot be done except by looking at things at the time. So,
Yes.
was it reasonable to pay the ATE premium? Was it reasonable to have a conference with the expert? Was
Yes.
it reasonable to do anything you can think of? Has got to be examined at the time.
Yes.
So, would you say that it follows the costs judge has got to examine what was done from the viewpoint of the time when it was done
Correct.
for the reasonableness test?
Correct. Yes.
Is there an additional burden then if proportionality is to be adjudged from events at the time,
Yes.
or is it not?
Yes. Absolutely. Because the
I appreciate it's a different criterion.
different criteria, but it
Does
must be.
carry a different burden? That's what I.
The burden for the court is to, if it's raised, is to apply the question of what is proportionate at in that same approach, same way, so that you look at what was being done at the time.
But if you've already identified the relevant characteristics, the relevant criteria, the relevant considerations to decide whether it was reasonable
Yes.
at the time, what additional evidence or work do you need to decide whether it's proportionate?
Very little more work. I mean, it may be. I mean, it doesn't involve a huge amount of work to then say, actually, it's also proportionate.
But that depends upon whether reasonableness is an issue or whether it's the same as proportionality.
Yeah.
If you're only concerned with proportionality and not with reasonableness, for example, or necessity, then that would be a new exercise.
Well, if I may say so, I think it's flipped the other way. The reasonableness is always engaged. Proportionality might not be. So, for example, if you have a case where the damages are £1 million and you've incurred 50,000 in costs, it's very unlikely that proportionality will ever be argued in the bill. It'll just be a question of what was reasonable. So reasonableness is always going to be looked at, whatever the outcome of the case. Proportionality might not be, but if proportionality is, then I agree with my lord that you could, at that point, you can consider, and indeed should consider, proportionality if invited to do so. If that's the challenge that's being made by the opponent, then the court should have to rule on it, and it should be based upon what was being undertaken at the time. The two-stage approach is one solution to proportionality. I submit that it's open to a judge to deal with proportionality as you go through the bill. You couldn't then at the end stand back and say, because there's sort of double jeopardy if you do. But if you, as an assessing judge, say this is a reasonable proportionate expense to take, to incur, then you've done your job under the rules. The rules don't say you should do this reasonableness and then stand back. I mean, it's entirely led by commentary in Sir Rupert Jackson's report, which just proposes an approach. My own experience, and on the ground, not that I'm doing lots of these cases any longer, but certainly my understanding is that many judges do just that. They actually look at proportionality and reasonableness as they go through it.
So they don't go through the bill twice.
Not every judge is doing the two-stage test.
Because that seems to me to be an extraordinarily gloomy prospect. That I understand that you have to go through the bill once, and I understand that you have to ask yourself, well, was this reasonable at the time, or if proportionality is an issue, was this proportionate at the time? But whilst I can see logically that there may be some force in saying, well, you have to look at the overall figure that you're allowing as reasonable and then see if that's proportionate. By the same token, I would, speaking for myself, I wouldn't be very enthusiastic about a proposal as a result of this appeal, which led to a requirement that judges have to go through it twice.
No, but I don't think it's as that. I would agree with that, but it wouldn't be going through it twice. It would be just, if you're applying a two-stage approach, at the very most, I think what you would expect would be that the judge would reflect upon the decisions made by reference to categories of cases. I can't see any force in submission that he should go through every item again. But what he can do is say, look, there are certain items here, categories of costs, which I'm not going to play around with. They were necessary. When added together with all the other bits, we've got to a point where they're disproportionate. But if I reduce the other bits, which were not necessary, but just allowed on reasonableness, I can arrive at a figure which I'm happy is proportionate. That's the approach that we would suggest. The alternative is that, as Master Brown, I think it was in one of the, it's not in the case, but Master Brown, one of the cost judges in the cost office corridor, he has said in a case I remember where he did say, let's just do it as we go through, and then you don't have the second stage. Again, it may be that that's an appropriate approach to take in the particular case. Whether the Court of Appeal wishes to say in all cases it should be done this particular way or not is a matter for your lordships, but from experience, the court may prefer to leave some flexibility in the approach, particularly as it's not rule-led. I mean, it's unhelpful that the rules are as they are. There isn't a practice direction that says, when assessing proportionality, you should do this. But we are where we are.
We're criticised if we make rules.
I know.
People say the rules are too long, and then we're criticised if we don't.
I know, I agree, I understand that. But this, I mean, in terms of this particular rule, if I may say so, this particular rule is at the heart of the civil justice system. This is a rule which, it's not just about whether, it's not a rule saying you must serve a document by a certain time. This proportionality thing lies at the heart of the system of costs. It's a vitally important ingredient within the civil procedure rules, and it might be said, certainly there was some sympathy from the Court of Appeal when I was last before on this issue, that actually the Rules Committee should probably look at this and come up with a solution rather than leaving it to the Court of Appeal to sort out. But it was made very clear by Sir Rupert Jackson, I absolutely understand this, that his firm view was that there should be judge-led guidance on these things, and the Rules Committee accepted that, and so there is no practice direction which assists us. We are 6 years in and don't have the guidance.
Did Sir Rupert Jackson indicate when he was talking about proportionality that he was talking about an end figure or something else?
Yes, we'll come to his report shortly, but he was clearly of the view that, well, he suggested that you look at the he suggested an approach which was firmer than what was ultimately legislated for. He said costs which are proportionate and only proportionate should be. I think they were the language of it. Only.
Yeah. It's
costs which are, if only. There's a lot of emphasis. They're proportionate. They should be allowed. The Rules Committee didn't accept that. Costs are proportionate if and only if the costs incurred bear a reasonable relationship to. If and only if. Now, the Rules Committee didn't accept that. The Rules Committee jettisoned the words if and only if, leaving, I would suggest, a greater degree of flexibility on what can be recovered as proportionate costs.
What? How does he go on?
Well, he goes on to use the same factors. The sum's an issue in the proceedings. The sum's an issue. We'll look at them in a moment. The value of any non-monetary relief in issue in the proceedings, so not as ultimately claimed, awarded, the complexity of the litigation, and the additional work required by the conduct of the other side, and any other wider factors. So, and I think at that point, I mean, I'm jumping right ahead, but just to illustrate the problem of the two-stage test where you say at the end, I'm going to allow 40% or something. Take a case where a defendant has caused the claimant to incur a whole load of costs, which they do. I mean, it works both ways, but I'm acting for a claimant, I might as well put it this way. The defendant causes the claimant to act and to undertake a whole load of work, insists on doing it. And so you say, okay, well, we'll do it. Claimant undertakes the work. When composed alongside all the other work that's been done, you end up with a disproportionate figure compared to the sums recovered or whatever it may be, and the proportionality is engaged. The judge goes through the reasonableness test and says, I'm going to allow this because you caused this, Mr. Defendant. I'm going to allow the claimant this cost. I'm going to allow on the basis of reasonableness, it was reasonable to do it. He then arrives at a figure, and the figure is still disproportionate. It would be wrong, we would submit, for the court to then just say, well, I'm going to reduce the whole lot by something to arrive at a new figure, because you're unravelling.
There might be two answers to that. You might say, well, because of the actions of the other side, wouldn't be Mr. Malladew's clients, of course, but the actions of the other side, you had 9 interlocutory hearings initiated by them which you had to attend.
Yes.
But the result is that you have got a cost bill which was reasonably incurred but is disproportionate to the recovery. But then the court is left with the discretion because of the magic word may.
May, yes.
So that it would be open to the judge on
Yes.
one reading of the
Yeah, well, that's our reading of
say,
it.
well,
Yes.
it was disproportionate, but we're not going to disallow it because it was the other side's fault.
Absolutely. So that's one solution to it, which we obviously support in our written argument. The other, it supports my submission that if you are doing a two-stage thing, you should think very carefully about what you're going to reduce. And this was an example of where you would sit back and say, well, I'm not going to reduce the 9 interlocutory hearings. That was your problem.
Yeah.
It was but I will reduce the other bits. And so there's a forensic exercise, not just a holistic view. This is not proportionate, which is what is happening, and we've submitted is quite wrong. It does, in answer to Lord Justice Coulson's concerns, require the judge to engage again in a further process of assessment, but it's not as demanding as my lord was suggesting. In other words, I'm not suggesting that you go through every single item again by any means. That's counterintuitive to the court's management of the case. But there does need to be some mature reflection on what it is that's being reduced to arrive at the proportionate figure. What you cannot do is simply, or permit, we would submit, is the judge to say, well, I'm just going to allow 60,000 and that's the figure. And as I say, that is happening in cases, and it's wrong. There has to be a principled reduction based on proportionality. It might be that it's difficult for the court to articulate, but that's not the problem of the receiving party. So that's a whiz round. That's a whiz round the problems. Perhaps I can just. Could I just go to the cases? I don't know to what extent your lordships want me to go to the individual cases just to see what was being argued below and how it sort of materialised, because these are very typical. And then I was going to go to the legislation to set the framework. I was going to say something about the report, the assessor's report, draw out some key paragraphs of that, and then turn to the grounds in a little bit more detail. Starting with the West case, it is a little tedious this, but it sets a scene. File 2 will be the relevant bundle. And at page 674, is the bill of costs. And I know you're familiar with these sorts of documents. There's a 675, there's basically a narrative about the underlying case, which I'm not going to go through. We've explored all that in writing. Requirement for expert evidence at 676. Settlement for £10,000, was any settlement, funded by a conditional fee agreement. And the ATE insurance premium is claimed at page 681, item 23. £5,088, including IPT. And just casting your eye over page 680 and 681, you'll see that a number of reports were obtained for experts' reports on condition and prognosis and liability and causation by this claimant on the 30th of May, the 5th of December. There was a conference with counsel with the expert in February 2015. And then there was also some reports obtained in respect of psychologist input, a psychological report. And you'll see from page 682 how the fee claim is broken down. £14,000 worth of profit costs, experts' fees of 5,930. Add it all up, you get to a figure of over £30,000. The ATE documentation, really for your note, the various disbursement vouchers are all there. The ATE, page 713 is the policy schedule. There's also a policy schedule at 703, but for reasons I needn't. In fact, it is 703. It's the one at 703. I'm sorry, it's 703. It's the one you need to look at. The one at 713 you can ignore. 703 is the policy schedule, was incepted in December 2013. For a premium of 5,700, of which, in italics towards the bottom of the page, 5,088, including IPT, is recoverable.
Where are we looking at now?
That's what page 703. There's a box in the middle of the page saying premium, 5,700, and then IPT on top, 6,042. And then down the page, under the heading notes,
No, in italics.
in italics, there's a figure of 5,088, including IPT, which is the equivalent of 4,800 plus IPT. That's the element that's recoverable under the regulations.
Well, the idea of that is to mean that the claimant does have some loss if it doesn't.
Absolutely, there is a
risk carried by the claimant as
there
well
is.
as by the insurer.
There absolutely there is. Yes. And of course, what we say is that if we end up in the world that Mr. Malu's clients would prefer, where these premiums being allowed at £600, whatever it was in one case, and that recoverable element will obviously impact on the claimants. Claimants will end up having to pay through their damages the shortfall in recovery of the premiums, and it will affect their ability to obtain access to justice and so on, which I'll come to the policy arguments shortly. But that's the premium. What then happens is pretty standard practice. We're hoping in the light of the assessors' observations about this practice that it's going to stop, because the assessors in their report, there's a veiled criticism of the way that the NHS has proceeded in these matters. But what you get is a point of dispute at page 714, and and you have a series of general points, and you always get at 715 a challenge on proportionality at point 4, and you always get a challenge to the premium, which is at page 723.
Hang on, so reasonableness is challenged. I'm sorry,
715
is
is they raise proportionality against the total costs,
yes.
the base costs. So there's no proportionality challenge to the premium. Base costs means, my lord, the profit costs and disbursements, not the additional liabilities. They took the point at page 716 that the claimant took out the AT premium on the 6th of December. They were saying that it was premature to take it out. That point is
Where's
now
that?
gone, because in McMenemy, this court, well, there was a whole series of appeals, my lord, where this point was raised, and the Court of Appeal said no, we're going to apply the pre-Jackson principles of Callery and Gray, and it's reasonable, perfectly reasonable and indeed proper for a claimant to take out these policies right at the outset when they incept their conditional fee agreements. So there should no longer be any argument about timing. But in addition, they challenged the amount of the premium at page 723. When you'll see point 15, and they refer to the paying parties' submissions and documentation are annexed to the point of dispute. And then in support of the submissions, you get the annex at page 725, which is rolled out in every case. They used to, but as I say, hopefully now will not, serve very extensive, what might be called extensive Part 18 requests about the premium. You'll see that on page 725.
This is a standard that happens every time.
Yes. As I say, we're
It's not, and that was expressly dealt with in the assessor's findings.
well in the vast majority. Mr. Malu will doubtless accept that in the vast majority of cases, there is in claims against my clients, these are standardised objections that are made to the premiums that have been recovered. I mean, not least, they appear in both cases. We'll see them again in the other case. So certainly 2 out of 2
We've had 725, which is the other page you referred to.
So, whilst I'm in 725, what it does, it sets out some questions, and then over the page sets out points about the overriding objective of the proportionality test. And at little 4b at the bottom of page 726, it sets this hare running. And I'm going to call it the hare running because it goes nowhere in the end, but it's been pressed upon a judge, and the judge would probably entitled to react to it. That it's a matter of public importance that the court ensures that ATE premiums, if held to be recoverable in principle, are assessed in proportionate and reasonable sums. Say for a relatively small number of claims brought against other organisations, personally defending clinical negligence claims, AT premiums will be charged inter partes to the NHS LA, acting on behalf of the NHS Trust in England and Wales. The NHS LA paid damages and costs in circa 10,000 cases per annum. Post-Jackson, all of those claims continue to have claims for AT premiums brought against the public body. There is a very substantial impact on the public purse should the court fail to allow proportionate and reasonable premiums. And the evidence was given by the NHSLA, which I'll turn to later, and ask you to remember what was said there. Then over the page,
This is in every case, or at least in
yes, I mean, coming
certainly
in the vast majority
in
of cases.
every case in this appeal, let's say.
Certainly in this appeal.
And that's all I need to know. Both of the cases in this appeal have this interorum paragraph.
Lord, yes, the points of dispute in both these cases are essentially identical on the ATE point.
Yeah.
Those points of dispute were used in a number of cases, particularly in the early days of ATE. Particularly in the early days of post-April 2013 ATE. The points have developed over time.
Yeah. Well, probably says it all. What the document then does is seeks to propose an appropriate figure for the premium. You'll see at page 727. It just applies some very simple but completely inappropriate mathematics. It says that the maximum exposure was £1,250. That's the cost of the medical reports. The prospect of paying out that sum was roughly 25%. And then they multiply that figure by the 1260 and arrive at a figure of 787, which includes a bit of profit to get to 834, I think, including IPT. It's a very rudimentary.
What does it mean, the prospects of paying out in respect of liability?
So they're saying the prospects of the claimant losing effectively and having to pay those costs themselves, so they have to claim on the policy, were very, very low.
If they told you that earlier on, you might have settled it more quickly.
Well, indeed, but the point of these premiums is that they're taken out right at the outset, as we shall see from the Court of Appeal in McMenemy. It's a case which supports our proposition.
But then we get to that.
Then we get to LAMP. Yeah. So that's point one. In the alternative, and just so that you are aware of it, on this calculation point, the assessors concluded that they had received no evidence that suggested that the way that our premium was calculated was in any way capable of being said to be incorrect or inappropriate or out with any underwriting principles. In fact, no case was put by Mr. Malley that they could have done it a different way. We'll see the conclusions. And we completely destroyed this elementary sort of approach. The other alternative is that there's a comparable premium offered by a company called LAMP Services Limited, which has now gone out of business, as you know from our recent skeleton. It was in business at the time that evidence was given by LAMP at the hearing earlier this year. But what they do, the NHSLA or their representatives, Aki mentioned, is that they produce this thing, they produce the policy schedule and say to the district judge, who might not be experienced in cost matters or who may be, look, you can get these premiums for a lot cheaper, and you see them at page 750. This is the policy that Mr. Justice Kerr and his assessor has referred to as the albatross.
Pregnant albatross.
Pregnant albatross.
Who invented that?
Mr. Cousins invented it, but it was basically describes the problem, which is that Act you mentioned on behalf of the NHS lay even rely upon this policy in LAMP cases where clearly this LAMP policy isn't available. I mean, it's quite absurd. But what they do is they put this document in front of the judge and they say, there you go, we've overcome the evidential burden of establishing what is putting us to proof as to reasonableness, such that you're now able to reduce the premium claimed on the grounds of reasonableness. We say that's completely wrong. You're not comparing like with like. You're relying upon a policy that we now know to be in fact was not even available, and as a consequence, this decision on reasonableness in the West case must be set aside. It's very clear. We would submit that has to follow.
Is this right? I note from the small print, which I can just about read, that they're based in Gibraltar.
Yes.
Which is the relevance of why it's the Gibraltar Supreme Court who've allowed their application for
Yes, all of that
liquidation or something.
Regulator would be based and subject to there, and any decisions presuming its insolvency will doubtless be resolved through there as well. But what then happens is that in this particular case there is a provisional assessment, which was a process, relatively recent invention of the Rules Committee, a good one, which enabled the parties to say to the judge, could you just assess this on the papers? We don't want to turn up. Here's the bill. And a judge will, in his room, go through the bill, look at the point of dispute and arrive at a figure based upon the papers alone. And the provisional assessment here was conducted by District Judge Iyer. You see at page 754 his approach. And he helpfully, the bill is annexed as marked up by the master in this document of 754 right through to the back of the bundle. But you see what he, over the page at 755, under the heading of proportionality, which was a point taken on the base costs, as you remember, he says, insofar as the solicitor's profit costs, not including costs of drafting and checking the bill and counsel's costs combined as assessed above still exceed 10, they are reduced that sum. So he says, I'm going to allow £10,000 effectively on proportionality grounds, no more than that. And then on the premium, at item 15, just above that, 80 premium, disallowed, so he disallows the whole thing completely, because claimant does not allege that any inquiries are made about availability of litigation insurance and letter of retainer recommended ATE without any reference to this. There was so it wasn't disallowed on proportionality grounds at that stage. It was disallowed because he perceived there to have been no inquiries made by the claimant as whether there were alternative policies available.
So that's a disallowance on effectively a sort of burden of proof.
That's right. Yes, and it was on the basis he was assuming that there were available insurance because he was saying you haven't made inquiries about the availability of litigation insurance, having been presented with the LAMP alternatives. And we say that's what sets that hair running. Now, of course, as we know from the assessor's report,
Is that disallowed on grounds of reasonableness?
it's reasonableness, yes.
Reasonableness.
Just to carry the story through procedurally, there are replies to point of dispute are put in by the claimants. They're at 728 for your notes. You don't need to consider those. But what you do see is this challenge to what we say is actually a perfectly reasonable premium in the light of the assessor's report generates a huge amount of. I mean, the costs of the costs, I think, exceed the premium. The costs of the cost assessment. That decision then was, so he reduced the costs on the provisional assessment, and then so there was an application back to the district judge for an oral review, which you see at 668. So having informed the parties of his decision on writing, the district judge then at 668, District Judge Iyer, gives a judgment having heard submissions, which is the judgment that his on Judge Smith was ruling on when he was invited to deal with the appeal. It's a very short judgment, which is no criticism, but it tells us that he says it was a claim that was never going to be very high in value. He refers to the insurance premium regulations, page 669. I'm sorry, my lord.
669. Oh, judgment.
669. He says that paragraph 1, the part of the premium related to the costs of such things as doctors attending conferences cannot be claimed. I need to attempt to make an informed decision about what the recoverable costs would be. I consider that any case involving at most 2 experts, relatively small sums of money, something I can do. Even if I had not seen any evidence about what the premium might be, that's a reference to the LAMP policies. Even if I had not seen any evidence about what the premium might be, in other words, what was also available, I would have thought that the premium really should not have exceeded 2,500. It's purely instinctive, unprincipled reaction to the claim. I do have evidence here, and that's the evidence of the LAMP policies. So although it's my instinctive view that 2.5 would be about right, actually it's consistent with the evidence I've got. That's how we understand him there to be ruling. There is a question about whether the evidence indicates an alternative policy, but I think that given the information that there is here, that the evidence is sufficient. And according to these, it does rather look at the claimant could have found insurance policies available to cover a figure that was no more than what the likely expert report cost would be, ranging from 2.1 to 2,332. My instinct would have been a figure of about 2,500, and that's what he assesses as being a reasonable premium. Not proportionate, but a reasonable premium. Reasonableness being the only issue in play. Now that we say is a most unprincipled approach to the assessment of the recoverable premium in this case, and it wasn't helped by the reliance upon the LAMP policy by Mullen and Friends clients. But it's very clear that we would say, in the light of the assessor's report, that decision simply cannot stand. Over the page, at page 670, I have already indicated I will allow the principle of the AT premium. So he allows, in principle, he has no difficulty with an AT premium being recovered, but even if my decision not, I would still have no difficulty allowing the principle of allowing the AT premium, because it is clearly something about which instructions have been taken and inquiries made. So in the end, he wasn't of the view that there hadn't been proper inquiries and so on with the claimant. So he just reduces it really on the ground that it was unreasonable, given his instinctive view about what a premium might really cost, and as influenced by the LAMP comparables. Turning then to...
So is that decision on reasonableness or
reasonableness? Reasonableness.
It's not a proportionality.
No, reasonableness.
Because proportionality for the ATE premium in West wasn't an issue.
Wasn't an issue, correct.
Proportionality was an issue, but in relation to the base cost.
Correct.
And he dealt with that on the paper generated by excluding everything beyond the amount recovered.
Exactly so, and there was no challenge to that. That just lay where it left. But, Demouilpied, just going through the similar, as I say, it is a bit laborious, but I think it's helpful. Page 507 is the bill of costs, same bundle.
So 507.
507. So again, you have the notice of commencement at 507, the narrative to the bill is at 510. So there you get to know about the facts of the case. and it's a case that settled 511 for a modest sum of £4,500. The original claim, just to perhaps bring in this
Sorry,
point,
which page was that?
511, the paragraph at the second hole punch, negotiations continue between the parties.
Thank you.
And just responding to my Lord the Master of the Rolls' observations about what was actually an issue, you can see from the top of that page that Mr. Jari's report, the claimant schedule of loss and part physics offer, it was in the sum of 7.6. So there's a compromise, but the sums at issue were more than what ultimately the matter settled for.
Twice as much.
Yes.
Well, no, it's a bit less.
Yeah, but a bit less. But I mean, you know, it's so.
It's substantial. It's
Yes.
substantial amount more than claimed.
Yes, and then you have the bill of costs setting out the work done. In the same way, you've got the experts report. There were less experts reports here instructed, and less experts. The expert was a consultant, orthopaedic and trauma consultant. At page 515, you see that report being obtained. And there was no challenge from memory to those reports. The premium is claimed at item 24, again at the 5088.
Sorry, 588.
Sorry, on page number 515,
Yeah.
you'll see the premium is claimed in the sum of 5088.
Sorry, I thought yes.
Well, it's partly mine as well, I think. It's confusing my fives. Item 24. And the premium schedule is at 545. Again, same premium as the other case. Is incepted in April 2014. 508, including IPT. And then you have points of dispute to the bill. Here we've troubled the court with what is a combined, yes, there's a combined at page 529. The points of dispute and replies are combined in one document. 529. Now you'll see again proportionality. The page numbering at the bottom right hand corner is pretty unsatisfactory for a part of this document. Second page in, 530. Point 3, proportionality. Apart from changing the numbers in it, the similar points are made. And then there's a reply to that. And then again, that's the excessive and disproportionate claim base costs have been incurred. So the reference there in proportionality to the base costs. But what you see in this case is that the ATE premium at page 585, sorry, 53, this must be 531, 535. At the top of the page is page 108. It's more helpful perhaps to look at the internal page. Point 10 ATE premium. The defendant challenges the ATE premium claimed and refers to the submissions attached.
I'm on page 108 internally.
Yes.
By the second hole punch.
Correct. Point 10.
Yeah.
And there's part 18 requests of referred to, and you get that document at page 538, internal page 111, where you see a very similar challenge. And here, the same approach to calculation is applied by those representing the NHS lay, where they say that the defendant submits that appropriate premium would be £175. You see that towards the bottom of page 540. This is on the basis that there was a 20% risk, so less risk here, of paying out £700 in experts' fees. But I mean, that just absolutely is a classic example of hindsight extraordinaire, because one doesn't know how many experts or what experts are going to be incurred, and these are block rated premiums. In other cases, we'll come to it, but the assessors make the valid point that the premium might appear to be disproportionate compared to the recovered damages in some cases, but in other cases they're dwarfed.
Proportion is the other way.
Yeah, absolutely, and so it's there's a. If we go down the route, just to interpose here, which is what the NHS I think still want, of having to look at every single one of these on a case-by-case basis, then we're in a pickle, because there'll be a lot of work for a lot of people, but it won't be, in my submission, a sensible approach to take, because a block-rated premium is a block-rated premium. It won't change depending on the facts. And once we've got through this assessor's report process and arrived at a point where this is a reasonable premium, we will be saying going forward, that is a reasonable premium, and it's a proportionate expense to take, just so I lay that ground, a proportionate expense to incur, so that we don't return to the current status quo of district judges being required to do this on every case in respect of a premium.
But you're going to have to deal at some point with how we regulate what is being done in the market, because you can't just leave the insurance market.
Yes, I understand that.
Otherwise, there'll be a terrible abuse, because they're seeking. At the end of the day, they're in there for profit. They're not part of the pro bono sector.
Yes, I understand that. Well, I will address that. I might just add that that the assessors have made heard evidence from ARAG that, in fact, on this book, they haven't made a profit. But
I understand that, and I absolutely saw the assessor's report on that. But all I'm saying is that the courts can't simply abandon forever.
I agree with that. I'm not going to push back.
An overall supervision of what the cost of access to justice is.
I agree with that, and it is a problem we have to grapple with. There is a market, but we will come to that in due course. So they propose £175. The matter then is provisionally assessed by District Judge Beard, page 579. On the heading proportionality, just so you see what's happening in practice, you'll see at page 580 the heading of proportionality, and what the district judge does is inserts in hand his decision at page 582, and forgive me if I get this wrong, but I will be exercising my duty when assessing the bill in accordance with the CPR 44, and in particular requirement to consider proportionality, consider criterion of proportionality when looking at the whole bill as required by CPR 44.3.2a. So, but he doesn't really say. I mean, he says I will be exercising my duty when assessing the bill in accordance with the rules, and be looking at the totality, the whole bill of costs. It doesn't really reveal what he's doing, but be as it may, the issue here is the ATE premium, which is at page 585, where he says, and if you need his own Justice Smith helpfully sets out exactly what he says at page 348. He says it here.
So give me that reference again.
348.
Sorry, in this bundle.
Yes, so in the same bundle, if you can keep your hand in 585, what His Honour Justice Smith does is transcribes what was said at paragraph 14 of his judgment at page 348. It's absolutely perfectly clear that he basically adopts the lamp comparable. Does my Lord have that? It's paragraph 14. In relation to proportionality, the Deputy District Judge noted that he would exercise his duty when considering the bill, and in relation to the premium, he noted comparable premium approach adopted. And that can only be a reference to comparing the alternatives. in satisfaction of achieving overriding objective and proportionality, defendant's comparable premium of 1982 adopted, that's the lamp premium. ATE was needed, but claim resolved after issue, so it's reasonable to incur ATE. So there was no dispute that it was reasonable to incur it, but he allowed the comparable of 1982. That decision was then subject to review by a different district judge, oddly enough. The idea here is that the provisional assessment should be dealt with by the same district judge, but it was Deputy District Judge Buckley at page 482 who came to review that decision of that district judge.
Hang on. So the first district judge,
Was District Judge,
Deputy District Judge Beard,
Deputy District Judge Beard,
and the manuscript is translated for us helpfully by Judge Smith at 348.
correct?
And what District Judge Beard did was to adopt the comparable premium of 1982.20,
Absolutely.
which was the lamp policy.
Yes.
Yeah.
Then there was
And then that's reviewed.
that's reviewed by Deputy District Judge Buckley on the 26th of April. The reference for that is 482, 26th of April 2016, so 3 years ago now. He reserved his judgment, and it was issued, I think, on the 11th of May, and you see that at 482. And, he says it's a review of a provisional assessment in respect of a single item, the ATE premium.
Sorry, just give me the page again.
Page 482.
482, thanks.
And he observes at the top of the page 483 that the policy was issued under a block rated scheme. He summarises the costs, and then really the key parts at 484. The defendant's initial challenge to the premium as alternatives may be summarised. The premium was unreasonably and unnecessarily incurred. The claimant was required to prove that the premium was qualified as recoverable under the regulations. It should be reduced as unreasonable and disproportionate to the amount. Cheaper premiums were available. The Deputy District Judge Buckley, at paragraph 12, stated that clearly the Deputy District Judge decided challenges A and B above in favour of the claimant. So this case has proceeded on the basis, and still does, that the premium was reasonably and necessarily incurred. There was no challenge by the defendant to that before His Honour Judge Smith. We're the only appellant in this case. So the claimant wins on it was reasonable to incur it. Indeed, it was necessary to incur it. But, as we shall see, Deputy District Judge Buckley concludes that it shouldn't be allowed on the grounds of proportionality. So we'll come to that in a moment. Over the page 485, paragraph 18, I conclude that the premium, in all its magnitude, was reasonably incurred and is reasonable in amount, but I still have to deal with the challenge that the premium was disproportionate. And he sets out the rules. There's a point of practice that's spotted by the Deputy District Judge at paragraph 23, which is that he says the provisional assessment procedure requires that after the costs officer has dealt with individual items in the bill, The form due will be returned to the parties to work out the arithmetic.
So where are you reading from now?
Paragraph 23 of the judgment at page 487, Lord. Sorry.
Yes.
So he's just pointing out a practical point that when you undertake a provisional assessment, the judge will give the answers to the various points raised, but won't actually do the mathematics and work out what the whole thing's worth.
So he's not in a position to do
Quite. Yeah, absolutely. Quite. Because until he gets the numbers back, you can't really stand back and. Neither party called for a review of the omission, therefore it's not for me to look at the proportionality of the bill as a whole. Paragraph 24. So then he just concentrates on proportionality of the premium. Paragraph 25. And he refers to Lowndes, the Court of Appeal guidance, a whole chunk of citations from the cases. And page 491 returns to his judgment. It was open to the cost judge under the old regime to disallow part of a disproportionate item in an otherwise proportionate bill. The new wording encourages him to be much more ruthless than previously in enforcing proportionality. He may, and indeed should, apply the third stage test to an individual item as well as applying it to the whole bill. To the bill as a whole. I have already said that in my judgment the claimant and his solicitor behaved reasonably in incurring the liability for the premium. Nevertheless, I do find that the amount of the premium was disproportionate in the light of the compensation targeted and the limited amount of the risk to which the insurer was exposed. What sum would be proportionate for the premium in this case? I have, in finding that the claimant's solicitor acted reasonably, rejected the challenge that because allegedly similar cover could be obtained more cheaply on an ad hoc basis, it was unreasonable for the claimant to take up this cover. However, even the price of that alternative cover would seem to me to be disproportionate. Although the review is being conducted for the benefit or non-destructions of the insurer, what is proportionate might be judged from the standpoint of the claimant himself. Theoretical though it is, the claimant needs an expert report on whether there has been a breach of duty. He is faced with the not insubstantial expenses of obtaining that. No one has told me what such a report would have cost in this case. It was never actually obtained. I think that a reasonable estimate of £1,100 to include any minor follow-up inquiry. If the report is favourable, the claimant can expect to recover that cost from the defendant, but if it's not, he will have to bear the expense himself. What is it worth his while to pay a premium to pass that burden on to the insurer? That itself must depend on the success prospects of the case, assessed as best they can be pending receipt of the report in question. I infer that the solicitor and client must have thought the prospects at least 50-50. I assessed the proportionate sum which the claimant could have justified a premium at £650. While I appreciate the block rate scheme with all its one-size-fits-all approach makes good commercial sense, I fear that the approach is not reconcilable in small claims such as this with the requirement of proportionality. That's the error. What he's done there on proportionality is just simply looked at the value of the case. He's excised from his consideration of proportionality all of the circumstances, which include the wider policy arguments which we will develop in due course, and we now know the findings of the assessors in terms of what actually was available. Because although he decided in the end that he wasn't persuaded about he rejected the challenge that the similar cover could have been made more cheaply, it's perfectly clear that I would submit that would have affected his approach to how he arrived at the figure of £650, or may well have done. But this was just an unprincipled approach to assessing a premium, which has been very carefully underwritten and does not bear any relation to the real cost to insurers of these cases.
Well, that's an issue.
It is.
I'm afraid. I thought you were going to say that it undermined the way that a block
Yes.
premium is reached.
I do say that, but
I mean, just to
that's
say,
what I mean to
which
say.
means that you can't. Well, The problem isn't. The problem is that he is looking at a risk assessment for this particular case, whereas that's not the way that the policy in these cases is calculated.
Correct. He's conflating the two. He's accepting there's a block rated policy,
Yes.
but not assessing it as it was.
Yes.
That's really the
I mean,
problem.
well, let's just see what he's doing. What he's doing is he seems to be because he accepts that it's reasonable to have a policy. The way this is written is as though he's assuming that you could have got out there in the market something for a cheaper premium.
Yes.
For the risk that was involved in this individual case. Is that correct?
That's
Whereas the question perhaps he should have been asking, not that he shouldn't have been asking the question at all, but he should have been saying, arguably, well, I accept that this policy, bearing in mind the way it's calculated and the fact that the solicitor in question has to assign all their cases to the insurer.
Yes.
That's part of the way it's calculated. Had the judge known any of this.
quite.
Instead of saying that, he might have said, well, I find that even though it was necessary and reasonable to incur this cost, nevertheless the defendant should not have to bear it because, as a matter of policy, I'm required to, I have a discretion as to whether or not to limit necessary and reasonable costs to what it will be proportionate for the defendant to pay. So he didn't do that.
I didn't do that.
And so you say, right, therefore there must be he was obviously wrong about the way he approached it. But I think we're really being asked to do something more than that in this case. That we are going to be asked, well, what is the answer if he asked the correct question?
Yes.
I think that we've gone beyond that.
Yes.
What he actually did, as to what actually, if he'd done the right thing, what would the answer have been? Would he have retained a discretion? I think the answer is he must have retained a discretion.
Yes.
That's the may in the rules.
Yes.
But what we were debating beforehand in our exchanges with you was, okay, if you ask that question, how should the judge approach it?
So what? So
Have I made any sense there?
So the way he should have approached it is, we say once you get to the point that it was necessary and reasonable to take it out, as he held, and it's block rated, assuming the judge has all the information that we now know is available to him, there is a discretion to reduce it, but we would submit that it would be wrong to do so because the totality of the premium is proportionate given the lack of availability of alternative cover. It's expensive in terms of the damages recovered in this particular case, but not in others. And you look at the holistic, you look at all of the circumstances, you look at the effect of reducing the premium to £650 or some other lower sum than the amount claimed on the policy behind the regulations, which was to enable these premiums to be recovered from the opponent, to be paid by the opponent, to enable access to justice to take place. And when you do that, you end up, as you did in Rogers and Lord Justice Brooke's judgment, that you get very close to saying, we would submit, that something which is necessary in the context of these premiums, in the light of the policy, should be recoverable in full.
Yes, what I'm trying to understand is, another one seems to me to be, in what circumstances would a cost judge be entitled to say it's not proportionate? It's easy to say reasonable and necessary, therefore you recover in full because it's not disproportionate. That's an easy equation. But the question is there in reality any rational and appropriate basis on which the cost judge should say, actually it's not proportionate?
No, we do submit, it may be considered to be ambitious, but mature reflection isn't. We submit that actually it's not. This is almost like a fixed cost.
Right. Well,
Subject to the court's overall supervision. It's a cost.
That's your submission at the end of the day.
Yes.
Your submission is at the end of the day in relation to the ATE premium. Once you've decided, I want to leave out necessity actually,
Yes.
because I think once it is reasonable to have incurred that ATE premium, your case is there is no scope left on a rational and objective basis for saying it's disproportionate.
Yes. It's akin to the issue fee, conceptually, clearly if there are alternatives available and so on, you've got those arguments. But given the process we've been through and where we've ended up, I find it hard to distinguish this cost, which Parliament has said you can recover and take out and spend by an opponent, is really any different from an issue fee, where you start from the proposition that both the issue fee and the premium are necessary in this type of litigation.
Well, except that the issue fee is set by the government, so nobody could possibly say...
I did say, I agree, I did say to my Lord last rolls that subject to the court's supervision,
Yeah.
but subject to that point, we are in a similar world.
It's the same point.
Yeah.
If the court is obliged and able to take all the circumstances into account, that's the phrase in the rule, the question really is whether all the circumstances affecting the case include the finances or the economics of the block premium.
Correct.
Now, we're in the position now uniquely, but that's been investigated by the assessors.
Yes.
But of course, 2 years from now, dealing with not
Yes.
Iraq but another insurer, it won't have been investigated.
Well, the answer to that, the answer to the control point is, I'd venture to suggest, the Rules Committee. Because the way, I would submit that the way forward, we could have a system where we come back every 3 years and see your lordships and have another argument, but that seems to me to be unwise. But there could, that your lordships could say that with this particular category of cost, it's limited in its extent, it only applies in clean neck cases, it's an exception to the rule that you can't recover them. It could be managed through a committee like the Rules Committee that could review, a bit like the hourly rates reviews were historically reviewed by a subcommittee. And I know it's more work for my Lord Justice Coulson, but it's a way. There is a way of the court.
We've got quite enough to do.
Yes, I know. Well, I do appreciate that, but
So it could be managed in the same way as fixed costs, reviewed and modified.
yes,
Adjustment.
so long as the fixed costs, it could. I would need to take instructions from my clients actually about this, but the principle of fixed costs would probably sound all sort of terribly unhappy for them. But provided that the fixed costs approach, if it was applied, was conducted in a central way, and that the views of everybody was taken into account in arriving at a figure, that would eliminate the problem.
Your submission was that you accepted, when my Lord Justice Irwin put the point to you, that it was similar conceptually to something like an issue fee, but it was, you accepted, subject to the court's supervision.
Yes.
And so that does then raise the point that's been raised with you, namely what would we be doing in 2 years' time?
I know. Well, that's my answer to that is that it's a fair point. I mean, one doesn't want to say to this court, well, we'll just come back in 2 years' time with another appeal, because that isn't the central way to deal with this. Is for the Rules Committee to grapple with the issue, so that there is some form of review. If your lordships are of the view that one can approach on the basis that it's like a fixed cost, that has the benefit of not having assessments in every single case, but it would have to be subject to a review of some kind of body. There was at one stage I think Sir Rupert Jackson recommended the Cost Advisory Council. My Lord Justice Coulson will recall, but I don't think that ever got off its feet. But something.
You mean for this is the summary assessment of costs? What costs would be recovered?
There was that for alley rates, but there was.
That's completely fair.
I know, completely fair in the end.
That was a catalogue of disasters.
Yes.
But there would be another way, isn't there? I mean, because I'm going to try and curry favour with Lord Justice Coulson now, because I don't suppose he wants to run
No.
what you have in mind. What is to prevent the NHSLA, if they consider that a given provider of block premium ATE insurance is overcooking things, from gathering together half a dozen cases and taking a test appeal
Yes.
on the
That is the alternative way.
proportionality looked at as a system?
Yes.
Because you can't really do it.
You can't do it by case
You
by
can't
case.
do it case by case.
No.
You may say this case is so small you should never have bothered with ATE insurance at all. Now that's a separate point,
Yes.
and that may be rational, may be argued. But in terms of those cases where such insurance is thought to be reasonable and necessary, the problem then is a systemic one provider by provider, not case by case. Now,
Well-
that could be done by way of...
It could be done, and that's really what was going on with your lordship's direction in this case.
Yeah.
That is a possibility. I was slightly against it only because it requires
It's unbureaucratic.
and
It's not a state enterprise.
Yes.
It's properly tested by evidence. It's got adversarial aspects.
well, that's the key. So we would say, and we've said it in spades in our submissions, as you know, any such review or case, including this one, there would have to be some expert evidence to say, there would have to be some evidence to say, reliable evidence to say, this underwriting approach is wrong or unreasonable, whatever it is. That would be, and if there was that evidence, and if the court certified that it was over-egging the pudding, then I accept, of course, that the court would be entitled then to say, well, hang on, this has gone too far. I agree with that as an option. Yes.
I mean, it's more satisfactory because you don't do it automatically. You don't have a business
No.
committee saying every year.
No,
or
I understand
year
that.
Or whatever. And those who are liable to be paying under the system know what they've got to review.
So, right, thank you. So the consequence of this then, because you've dealt with now the regulation of the market, taking the possibility of either CPR committee or whatever, looking at that, or Lord Justice Irwin's mechanism to use in this case.
Yes.
And the NHS could then, and you're happy with that because the NHS can then decide what evidence to bring on that, and it can be challenged by expert evidence. And then
Correct.
But the effect then of your answer to me, which was that once you decide in relation to ATE premium as a particular item, once you've decided that is reasonably incurred, there's no scope actually for a reduction of proportionality.
Yes.
Is that the operation of 44.32A will have to operate in relation to all other costs.
Correct.
So what that means then is, for example, that the solicitor's costs
Absolutely.
will bear the brunt
Yes.
of any reduction in order to make the result a proportionate one.
That is so. Not just, it could be any other fees. See, it's fees that are capable of being. See, the 80, assuming the assessor's conclusions are correct, as long as we suggest they are. There's no movement here in terms of reasonableness on this item, but there may well be on. As I said, you could go to a more junior barrister. You could use less staff, or you could. There are legitimate ways of reducing the reasonable costs to reflect proportionality, which are principled. There isn't in respect of what is effectively a fixed sum for the time being. There's no other way of funding, of obtaining a
Right, I'm
premium.
just not sure of the extent to which the Law Society would be very happy with that result, because it would leave the insurers in a position subject to challenge, through market control, basically being guaranteed their, as it were, return, but it would leave other professionals. I'm not saying this is wrong, but I'm just thinking of the practical consequences, having to bear the effect of a disproportionate result.
Well,
Part of one of the ingredients of which will have been indeed the cost of the ATE premium.
well, I think what we would do, with respect, Master, my lord, what you would do is take out from before the master, you would the cost judge, you would take out the premium from the equation and see what's left. So you would then go to the solicitor's costs. And they of course need to be proportionate anyway. So that you're not really placing the solicitors in any worse position than they would have been before. They're quite able to say, on this stand back approach, look, my costs here are proportionate. We couldn't have done anything less in terms of the work we did. We couldn't have used anybody else. The barristers may say the same thing, in which case the assessing master may say, I accept that. I'm not going to make any further reduction.
So if you take it out,
It doesn't have to make a reduction if it's satisfied as proportionate.
so if you take it out, you say it wouldn't have that effect because you've simply taken it out of consideration. Like the district judge that we looked at, he wasn't dealing with the ATE premium. He was just looking at proportionality for the other costs, and did that by reference to what was recovered.
That's right. And Mr. Justice Marcus Smith, an authority we only, I think, days ago maybe, we put in, did something similar. He took out the issue fees. He took out things like VAT, and he took out the cost of the assessment as well, and said, I'm going to excise those from my decision about whether they're proportionate. So
the trouble is, if you go down this logic, each of which part of which you're applying to each stage of the process, you will have moved from a situation where the court starts with the Lowndes approach, which is basically to say, if the fee appears to be disproportionate, you only allow what's necessary. That's a very strict list. You introduce the ingredient of proportionality, which was supposed to be an introduction of something to reinforce the idea that you could still have something that was reasonable but disproportionate. And by segmenting the analysis in the way you've done and taking out the AT premium, you might end up with a situation where actually you can hardly ever exercise the disproportion element. So you've moved from a very strict system, one which it was intended to continue in a different way, to one where effectively there's very, very little control.
Well, I'm not sure. I suggest that it's not actually a fair analysis of the position, because what we're really saying is that the premium is a proportionate expense, so it satisfies the proportionality test for the reasons we will. So you're not therefore treating other costs less favourably because your costs are not in fact disproportionate. They are proportionate. You just move on to the other costs that may not be proportionate and see if you can reduce those. So there's no unfairness in that. And of course, this only tends to rise where the damages are low compared. And one has to be very careful about applying the proportionality by reference purely to the damages figure. Because if something is proportionate in a low value claim because you can't obtain it anywhere else, it's clearly going to be proportionate in a high value claim. And I think what our submission boils down to is it is a proportionate expense. It is a proportionate sum of money to spend. It's a proportionate premium by reference to what it seeks to achieve across the entire market, and should be allowed as proportionate. So that was the decision of the district judges. His Honour Smith's decision is at tab 24 of the bundle. Now, really, this is an appeal. Obviously, it's an appeal against His Honour Smith's judgment, but it's really an appeal against the district judges' decisions, because it's an appeal of an appeal, and he himself was reviewing the decisions. So So tab 24 sets out the various rules and deals with West at page 347 in terms of the underlying facts, and Demouilpied at 348, which I've taken you to already.
And then he sets out the authorities under proportionality.
He does. He says at the end of paragraph 19 that he doesn't need to opine on a finding about the correct. It says it's possible that rules committee decided not to fully implement the recommendation. It's also possible that they attempted to implement it, but that they attempted to do so. But he doesn't actually opine on the question which we asked this court to do.
This is the Lowndes point.
Yes. And then over the page, the second issue raised by Mr. Cohen is whether the court, when determining proportionality, can take account of factors which are not specific to the case. This is an important point. It's common ground that CPR 4435 sets out the factors to be considered, which are specific to the case in question, but he submits, Mr. Cohen, that CPR 44.4 allows the court to look at all the circumstances, and in his judgment he doesn't agree with Rand Jr.'s submissions, and says that in considering proportionality all the circumstances must refer only to the circumstances of the case. I mean, we say that's that's just wrong. I'll turn to the rules shortly, but it doesn't feel right either. I mean, of course, all of the circumstances must include the policy considerations behind the particular provisions, and the block rating concept, which necessarily involves consideration of things beyond the circumstances of the case. So his error at 22 is that he didn't take into account the wider issues relating to the ATE market, which clearly relevant. I mean, we would say, although it was no indication by any means of the court's approach, that was one of the questions which the assessors were asked to consider in some detail. And certainly it formed a backbone to Lord Justice Brooks' approach to proportionality in Rogers, as we shall see in due course. And then the paragraph 23 is the question of how proportionality should be determined. And he refers to the various cases. He doesn't consider it helpful to look at the decisions in detail, paragraph 25. Says, I see no reason why the test of proportionality should not be capable of being applied in the same way as the test of reasonableness. Although in practice there may be very few cases where an individual item of cost is disproportionate, even though the total cost figure remains proportionate. I see no reason why the court does not have the power to reduce or disallow such an item. And then he turns to reasonableness and the West appeal. Paragraph 35, he summarises our case that they failed to advance the material supporting reasonableness, referring to Rogers, they're block rated, you need some expert evidence to show that it's all unreasonable. Then at 37 he arrives at some principles. This is on the question of reasonableness, not proportionality. And on much of this I would respectfully agree with we would respectfully agree with the learned judge, although there's some tweaking to be undertaken, but it might provide a helpful starting point. 37.1, there's an evidential burden upon the paying party to advance at least some material to establish that the premium is unreasonable. We would accept that. The cost judge is not entitled in the absence of such material to reach a decision instinctively, which we would agree with that, but we say that actually that's what happened when the district judge...
You agree with that?
We agree with that, and that's one of the, in fact the district judge did instinctively in the case of West arrived at an instinctive £2,500.
And he says, and the Judge Smith says he wasn't entitled to do that.
Right. Yes. And then 3, if such material is provided, the cost judge may then adopt a broad brush approach and rely upon their experience. Now we disagree with that. What is meant by broad brush approach is there's a danger there. I mean, clearly, if a suitable comparable is provided, because if there is some evidence that a particular claimant could have obtained a policy at cheaper cost, then of course the judge would be entitled to have that regard to that, and decide whether or not the premium in front of him is reasonable or not. But whether he takes a broad brush approach, as opposed to saying, well, look, you could have got this for £2,500, I'm going to bought £2,500, is another thing. On the facts of our case, of course, the issue doesn't arise because there is no alternative cheaper policy available. But there might be other cases in the future which are not block rated. I doubt there will be, because most of the insurance providers in this market, as you know from the assessor's report, approach it in the similar way. And then we would agree with 4 that expert underwriting evidence will usually be required where the premium for a block rated policy is being challenged. Now, this was such a case, and his own approach doesn't appear to have been followed. the cost judge is able to intervene without expert evidence if the challenge is to an individually rated premium based upon the underwriter's assessment of the risk. We agree with that. I mean, there are cases where the challenge is that the underwriter, on an individual case, this is not block rating, but on an individual case, the underwriter said that the risks in the case were 65% or 7%, where you can challenge that without an expert saying they were wrong. You just say, well, look at the facts of the case. It doesn't take a rocket scientist to work out that you completely overrated the premium. And that's happened in the past. I can think of cases where that's happened.
So where a premium is calculated in an individual case on the basis that there was a very low percentage of success,
yes,
but in fact you look at it and it's an open and shut case,
yes,
then you don't need expert evidence
exactly
to say, well, that's ridiculous.
You don't. I mean, in the early days of the AT market, one would see a bit of that, but now the market is restricted, as you know, in terms of recoverable premiums in this way through these regulations, and there are only a limited number of insurers in the market, all really applying what is akin to a block rated approach. So in these cases, the risk of that over occurring are remote, but it's perfectly legitimate for the judge to have said what he said about that.
Certainly in my time, I've seen
Yeah.
cases where that has happened, where
Yes.
the percentage has been very high, the applied percentage has been very high because it's been said, well, the chances of success are very low, but actually you look at it and that can't possibly be right. You don't need expert.
You don't need expert evidence for that. Quite
So
so.
you agree with 5,
We do.
but your caveat is that's for individually
Yeah,
rated
exactly so.
premiums, yeah.
Exactly so. And so the conclusion at 6 is probably right. The nature of the material required and the nature of the task carried out by the cost judge will both vary depending upon the AT policy being challenged and the precise nature of the challenge. I mean, that's a fair summary of the
Well, it
position.
sounds that but so far as I can see, the only of those criteria that you disagree is in 3.
Yeah, that's
So you agree with
the other was that it seems to us that that's a fair
And
reflection.
3 is a slightly nuanced approach, isn't it? Because 3, obviously, if material is provided that meets the necessary test, you would say that would be difficult in a block-rated case. But
Yes.
if there was such material, then of course the judge, the court has to decide that. You say the problem with that is it conflates if such material is provided with this question of a broad brush approach, which,
Yes.
if you look at Surrey, might be said to be encouraging well, it looks a bit too high
Quite.
to me.
Yes, that's right.
That's really the point.
That's
isn't
the
it?
point.
Yeah.
Exactly, Bob, yes.
And although you agree with 4 in principle, you say it didn't happen here.
That's right. It was, but for your lordships, I mean, your directions, they were given the opportunity in this case to adduce expert evidence, and that hasn't happened in the end. But on any view, it seems to us that the judge's approach, for reasons that are not clear, he didn't actually follow his own guidance. And what he does is then applies these principles. So on West, he applies the principles regarding reasonableness. And paragraph 39, so paragraph 38 makes it clear that proportionality isn't an issue in the case. It's purely based on reasonableness. 39, accordingly, insofar as the judgment was based on an instinctive view that the premium was unreasonable, the district judge was not entitled to proceed in that manner. Well, we agree with that. However, this was not the only basis on which the district judge reached his decision. He expressly based his decision on the evidence before him, alternative lamp policies, and said there is a question about whether the evidence indicates an alternative policy. Now, we know now, and we're pretty, I would submit, confident that if we were before His Honour Judge Smith with this report, he wouldn't have held that the lamp policy was a proper comparison. So we can't criticise, I mean, it's well and good for us all now to criticise the learned judge, but he doesn't have the material that we had.
So that you say that's a reference to the expert assessment.
That's right,
So
absolutely.
that the assessment shows that it's not a proper comparable.
Correct.
And in relation to West, if you're right about that, that's it.
That's it.
Because that's the only ground
that's the only
on which district judge's decision was upheld.
Correct.
Because the judge himself, to be fair to Judge Smith, the judge himself said the instinctive approach can't be right.
Correct. And so at 43, as I said, I'm not criticise the learned judge because he's in a different position to your lordships, but on the assumption, paragraph 43 is assuming that the lamp policy was an alternative policy, and that's why he says the material provided by the defendant was sufficient to satisfy the evidential burden. But it wasn't in the light of what we know about the lamp policy. So that's a straightforward, we submit, almost an appeal on the facts. I know it's unusual to have it here, but the purpose of the review was to enable a fact-finding interrogation to be undertaken so that the wisdom of the judgment could be reflected upon maturely, and that we would say that clearly that decision has to be reversed.
43 at the first sentence, on the facts of this case.
Yeah.
Given the nature of the challenge, the material provided was sufficient to satisfy the evidential burden.
Yes.
Against where expert evidence was required because it was based on the potential availability of alternative cover.
Right.
It's as
Simple as that.
And you're saying, well, that was
Factually, that's wrong.
That's factually wrong.
That's right, my lord, yes. And then
I mean, then in a sense, that's the easy bit.
Yes.
If you're right, because even if you're right, you say, well, you'd still like guidance.
yes, because this is just an example of. It would be delightfully. Well, it would occupy lordships less time to deal with the case on the individual facts, but
There's no respondent's notice.
there isn't. There isn't. No.
There's no response notice on proportionality.
On a proportionality, no. So that's West. So far as Demouilpied is concerned, he says that it follows from his paragraph 45. He says that the deputy district judge was entitled, as a matter of law, to consider the proportionality of the AT premium in isolation. Remembering, though, at this point that the judge is proceeding on the basis that he's not allowed to consider the other circumstances. He's already held and told Mr. Kerrin, my Leonard Jr., that no, I'm not going to look at the wider circumstances. I'm just looking at the facts of the case when I come to proportionality. And when doing so, I can look at it in isolation, which we submit he can do. I mean, we would submit that the rules are flexible enough to allow costs, and the rules means costs individually or costs globally. He was entitled to take into account the compensation targeted. We agree, sums and issues. He's also referred to the limited amount of risk to which the insurer was exposed. Well, again, that begs the question, as we've said in our skeleton, that there he's, bearing in mind it's a block-rated policy, maybe that he hasn't appreciated the extent of that, but risk in a block-rated policy is not a risk by reference to the facts of the case, and that's the error. So he says that he was entitled to take that into account, and he would be entitled to decide that the premium was disproportionate. Then he goes on to say that, having reached this conclusion, it's surprising that the Deputy District Judge sought in effect to calculate a premium. This is the one where he arrived at £650. This was both inappropriate and potentially impermissible. When it was in our submission completely impermissible in the absence of any expert evidence about what a block-rated premium should be. Although he says, although insofar as he assessed risk, he was entitled to do so, but that's confusing risk in an individual policy with risk of a book behind a block policy. He goes on to say, moreover, as I have already indicated, it's unclear how he even arrived at the figure of 650. We would agree with that. As I said, it was an unprincipled approach that was taken, unexplained. However, it's clear that he was still considering the question of proportionality, and he expressly concluded that the figure of 650 was proportionate. Well, and therefore he says, I'm satisfied he was able to do that. But that's a bit of a circular sort of point. It doesn't. Yes, he's considered.
Well, the trouble with this is it's unclear what the judge is saying.
Quite.
the assessment of proportionality was assessed by reference to? Was it assessed by reference to the original claim? Was it being assessed by reference to the amount ultimately recovered? That's what's unclear about it.
Yes, it is. I would submit it's very unsatisfactory that the judge concludes in that paragraph that the fact that he used an inappropriate calculation to support that figure does not mean it was wrong. I mean, I would suggest that the law requires slightly more than that. I mean, if you arrive at a figure inappropriately, then to say, well, actually, he was entitled to arrive at that figure because he has a generous ambit of discretion. We're in an odd world.
And also, as you quite rightly say, he said in the earlier elsewhere that you don't take into account the right circumstances.
Yes.
So presumably that proportionality was calculated entirely without reference. Leaving aside there's an alternative policy, it was calculated entirely without reference to any wider considerations relating to the insurance market.
Quite so. Yes.
If the district judge had stuck with the original district judge's approach, the £1,982, which was the figure from the comparable policy,
Yes.
then that might make more sense.
Yes. We would
So
say
that I appreciate you're then back into the problem of
the facts.
In fact, they're not comparable policies on your case.
Yes.
But that would have made more sense.
It would. It would have made more sense.
Right, there we are, that's the judgment. Where do we go from here?
Well, my Lord, the next, I'm just looking at the time, I know it's slightly early, but the next section of my submissions was going to deal with the legislation and the rules. It may be that
No, you've got another 7 minutes.
we've got another 7 minutes. So let's start with, authorities bundle. In fact, it's probably helpful to use those 7 minutes just to sort of set the scene. So tab 1 of the authorities bundle this is section 58C, which was, as you see, the Courts Legal Services Act 1990, 19th of January 2013. 58C permitted the exception to the rule that after the event insurance premiums are recoverable in cases. What this did is it carved out an exception where the party to proceedings who has taken out a cost insurance policy may not include provision requiring the payment of an amount in respect of all or part of the premium unless such provision is permitted by regulation under subsection 2. So it starts in the negative. It says you can't recover a cost insurance policy unless you're permitted by regulation to do so. The Lord Chancellor may make regulations that provide a cost order may include provision where an order is made in favour of a party to clear and neg proceedings of a prescribed description. B, the party has taken out the cost insurance against the risk of incurring a liability to pay one or more experts' reports. It's a prescribed form of described policy. It tells us what the premium relates to, how much of the premium relates to the liability for an expert's report, and the amount to be paid in respect to the relevant parts of the premium. And then the regulations may themselves prescribe a maximum amount, Regulation 3, and you might recall, and this was part of the argument I argued in McMenemy and failed, that here Parliament was seeking to introduce a scheme where the courts actually wouldn't be bogged down in assessments about the premiums because the legislation would set prescribed amounts, and I lost that argument on the basis that these are costs within the meaning of the civil procedure rules and therefore subject to the court's jurisdiction. But you'll see that the regulations, the Act, Section 58C, it may prescribe an amount, specifying a percentage, and so on. Now, under those regulations, under that Act, regulations were first promulgated in January 2013 behind tab 3. It's the 2013 number 92 regulations. These were incepted and then revoked, but it's part of the history of the legislation. You should be aware of these regulations. So this was the first set of regulations. They were intended to come into force on the 1st of April 2013, but they were revoked on the 26th of March, only days before. And this is something the assessors have regard to in the report, where they say actually companies like Arag and DAS and the others were put in a quite difficult position because it wasn't until very late in the day that anybody knew what was actually going to be recoverable under the statutory scheme. But you'll see that under the original regulations, Regulation 2.2, a cost order may not require the payment of an amount in respect of relevant part of the premium, which relates to liability to pay for an expert report if the report was not in fact ever obtained. That was one of the conditions. That's now gone.
Well, none of this came.
None of this came into force. So they came into force, and then there was a huge objection to it, and social uprising, so to speak, and it got revoked by the regulations that appear behind tab 2.
So what's the significance of it?
Just part of the history. Just part of the history. The reason why I refer to 2.2a is that was the point that was developed in one of the cases. You remember the defendants were contending that the report hadn't been obtained in, I think it was Demouilpied, where therefore it shouldn't be, the premium shouldn't be recovered in full or at all. Now, the fact that Parliament in the end revoked that element of it suggests that even where a report isn't obtained, you can still recover the premium, which you clearly can, because that's what the Court of Appeal said in May. So then we go to the recovery regulations at tab 2, made on the 26th of March, came into force on the 1st of April. I'm not going to read out the explanatory note, but it should be part of, I would respectfully suggest, part of my Lord's reading. The conditions now in Regulation 3 are the value of the claim is probably more than £1,000, and the cost insurance policy insures against the risk of incurring a liability to pay for an expert report or reports relating to liability or causation in respect of clinical negligence. The amount of the premium that may be required to be paid under the cost order shall not exceed that part of the premium which relates to the risk of incurring liability to pay for an expert report or reports relating to liability or causation. So that's the element of the premium that was investigated by the assessor.
So it's common ground that these premiums are recoverable under Regulation 3, subject to all the arguments in the case.
Absolutely it is, yes. Then behind tab 4, I don't know whether your lordships would prefer to work on when we come to the CPR to the authorities bundle or the white book. One has different experiences, but you might find helpful the extracts at tab 4 of the authorities bundle, which is Rule 44.3. And just before lunch, I just want to lay this seed that on the ground of appeal relating to all of the circumstances, it seems to us to be so straightforward. 44.3 tells us that the standard basis or the indemnity basis, under both of those bases, the court will not allow costs which have been unreasonably incurred or unreasonable amount. 44.3.2, where they're assessed on the standard basis, the court will allow only costs which are proportionate to the matters in issue, costs which are disproportionate in amount may be disallowed or reduced even if they were reasonably or necessarily incurred. I emphasise the word amount because it's different to the words proportionate to the matters in issue. Then there's a section about resolving doubt, which is a familiar passage. And then brackets, factors which the court may take into account are set out in Rule 44.4. And Rule 44.4 is included in this clip, this authorities clip. And it's at page, if one turns, top right hand corner there's some pagination. If you go to page 15, it's a photocopy of the white book. Over the other side of the page becomes page 1, so after page 15 you see 44.4. You turn to page 15 and then turn the page again. And when you look at 44.4, it says in very clear language, the court will have regard to all the circumstances in deciding whether costs were proportionate, reasonably incurred and so on. So we say the judge was quite wrong to reject Mr Cohen's argument that the court may only confine itself to circumstances relating to the case itself. He got to that point because he was reading from 44.3.5, my lord, which going back to the first page in tab 4. Costs incurred are proportionate if they bear a reasonable relationship to the sums at issue in the proceedings, the value of monetary relief in the proceedings, complexity of litigation. And it's quite absolutely accept that those factors are certainly A, B, C and D are specific to the particular proceedings. E, wider factors involved in the proceedings, such as reputation or public importance, might also be similarly treated. But what the judge's error was in not reading 44.3 in parallel with 44.4, because the rules prescribe that all the circumstances are to be taken into account in determining whether they were proportionately and reasonably incurred. And he's 44.3.5 just gives, as His Honour Judge Dyke in the May case said, they highlight for the assessing judge the particular factors you have regard to, but they don't exclude the consideration of all the circumstances. It would be very odd if they did, we would submit. That's really probably an appropriate moment to stop.
Yes, well, thank you very much. 2:05.
Was